Ron and I decided to do this presentation because he and I have had trade secrets cases over the years. We're both in our firm's litigation practice group. So basically, we're dealing with disputes, situations that have come up. We're not typically dealing on a day-to-day basis with clients and planning. And so oftentimes, as it relates to trade secrets, and you'll learn more about this as we go along, by the time Ron or I are involved, the horse is out of the barn. And we're left looking at what's there, what can we do, whether we're on the side where the trade secret has been misappropriated or on the side where a demand has been made or a suit has been filed to enjoin or stop someone from, or some company from using certain information. So what we're going to do is this. Initially, it's going to be sort of a primer. I'm sure you're all familiar with trade secrets generally, but we're going to go through the definition under Ohio law and some details related to that. Then Ron is going to speak and present on what's called the Defend Trade Secrets Act. It's the first federal law, and it was passed last year, that actually provides for a civil action in the event of misappropriation of trade secrets. And that's a sort of a landmark law because up until really last year, it has been said that trade secrets are sort of the stepchild of intellectual property. There was, patents, copyrights, trademarks, there's federal legislation that covers those. Up until last year, nothing dealt with trade secrets, which for many businesses are more important. Many businesses don't have patents, and they don't even really they should have trademarks, and maybe they don't have copyrights, but most businesses do have trade secrets. And just to do a survey here, by show of hands, I would ask, how many of you in your business believe that you have what would qualify as trade secrets? Most, but not everybody. Okay. For those of you who do have, or maybe even if presently you don't have, has anybody been involved in a dispute or in a situation where there was a question as to whether a trade secret had been compromised? Has anybody dealt with that kind of situation before? All right, you're all fortunate because those get to be very testy and emotional and difficult situations. So I'm going to start off by talking about, and our title here, Building a Wall Around Your Business, Trade Secrets. You can see where that came from. But the idea is you do need to protect information that you consider to be extremely important. And if you don't, you risk it disappearing. And that information, if it does give you a competitive advantage, it needs to be protected. Otherwise, you're at risk at losing it. So what is a trade secret? Now, this is taken from the Uniform Trade Secrets Act. Most states have adopted it, including Ohio. This has been the law for some time. And you'll see, trade secret, by the way, we have, you can grab on your way out this PowerPoint. Some of you may have picked it up on the way in. And this is a very broad definition, but this is the law. Trade secret means information including the whole or any portion or phase of any scientific or technical information, design, process, procedure, formula, pattern, compilation, program, device, method, technique, or improvement, or any business information or plans, financial information, or listing of names, addresses, or telephone numbers that satisfies both of the following. So just that part of it, it's hard to think of many other words that you couldn't, that pretty much covers everything in terms of information. So it's got to satisfy both of the following. It's got to derive independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use. What that means is it's got to be a secret. And then secondly, and this is the second one is really probably the most litigated and disputed part of whether or not something qualifies as a trade secret. It is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So, as I said, the first part, it's got to be a secret, and that sort of implied in the name trade secret, but a lot of people, in my experience, have, they will say, well, this is confidential, this is proprietary information. When you really look at it, it may not really be something that's truly a secret Others may know of it, particularly we're talking about competitors, may have access, may have that same information. So the first question is it really, is it truly information that others don't have, and that by having it, it gives you a competitive advantage? The classic example of a trade secret could be a list of clients or customer lists where, these names, or you could get them out in the public domain, but when you have a list that maybe your sales or marketing people have spent time, maybe years generating, it's got the name of maybe your client or prospective client. It might have the name of the contact person who makes certain decisions, email or phone number, might have some history in that client, the buying cycles, that kind of thing. That information typically will qualify as a trade secret as long as reasonable efforts are made to protect the secrecy of the information. Ohio Revised Code, there's the section of the Revised Code. All right, what factors are considered in determining whether certain information will qualify as a trade secret? And I want to run through this, and I'm also going to say, Ron and I are not going to go through our whole PowerPoint. There's a lot more information there. We just don't have time, and so you can see for yourself on some of that, but the high points we're going to cover. So what factors are considered in determining whether certain information will qualify? For one, the extent to which the information is known outside the business. If it's known outside the business, it's not likely to be a trade secret. The extent to which it is known by those inside the business, i.e. by the employees. And that, if it's truly a trade secret, depending on the size of your business, it probably shouldn't be known by everybody. There should be select access to that information. The precautions taken by the holder of the trade secret to guard the secrecy of the information. And whether we're talking about tangible information, it could be documents, it could be a manufacturing process, it could be a specially designed fixture or jig or something in manufacturing. It could be a list of customers or vendors, pricing information, margins, financial information. There have to be precautions taken to guard the secrecy. With computer access, obviously that's got to be limited. With documents, you want to mark documents that truly are proprietary or confidential, so that inside the company, it's everybody who looks at it can see this is designated as confidential. The savings affected and the value to the holder in having the information withheld from competitors. If you spend a lot of time and effort developing what would qualify as a trade secret, and that can get out easily enough, and a competitor of yours can just get that information without spending those years developing that information likely will qualify, again, as long as you've done something to maintain the secrecy. So when you dedicate resources to developing a trade secret, maybe it's you've developed through research and development, you developed a new product or a manufacturing process, you don't want your competitor to get to that information because they didn't go through what you had to get through. You've all heard about reverse engineering. That's a legitimate, and it's a defense to a trade secret, where if a competitor obtains, let's say it's a widget that you've developed and it's specialized somehow, if they can legitimately get the widget and have their engineers look at it, take it apart and figure out how it was done, that's a defense. That's not any kind of a misappropriation of a trade secret, because we're not talking about patents. That's a whole different subject matter. The amount of effort or money expended in obtaining and developing the information, typically if we're presenting in court information as to establish a trade secret, we want to be able to show that this just didn't happen overnight. Our client spent a great deal of time and effort and took time and money to develop this information. And the amount of time and expense it would take for others to acquire and duplicate. So it's not something that a competitor can just go out and buy this list or develop it overnight. It would be expensive. Examples of possible trade secrets: business plans, marketing and sales research, strategic plans, target markets, financial information, pricing formulas, internal costs, profit margins, listings of name, addresses, or telephone numbers of customers, suppliers, representatives, referral sources, scientific or technical information, research results, tolerances, design, engineering drawings, manufacturing processes using machines, fixtures, materials, and fluids, And of course, formulas, everybody's heard about the recipe for Coke as being sort of a classic trade secret that's supposedly locked in a safe and only a few people have access to it. And so that's why it would be a trade secret, and they take great measures to protect the secrecy of their formula. And real quickly, I want to run through, and what we're going to do once I've finished this and Ron speaks to the Defend Trade Secrets Act, we're going to get into some real situations we've experienced and some cases, just to kind of give you an idea of the kinds of situations that actually come up in business, which lawyers and courts have had to address. So, but reasonable measures designed to maintain and protect trade secrets, limited access to people with a need to know. That's disclosure made on an as-needed basis. Employees should sign contracts and acknowledge in employee handbook policies that you have proprietary or trade secret information. And it really should be, if it can be, somewhat specifically identified as opposed to generally saying we have proprietary information that we consider very, very important to us. If your employees don't really know what you're talking about, it's not going to do much good if somebody leaves and somehow that information shows up in the competitor's hands. Include non-disclosure covenants. Those are important, and those can be signed not only by employees, but visitors, vendors, people coming to your office or plant. Covenant not to compete for employees and independent contractors. In some businesses, those are not, it's just not customary. You're not going to, no one will come to work for you if you insist they sign a non-compete. But when you can have it, in many businesses, they are customary, and those are very important measures taken to protect, to limit their ability to go out and use whatever information they've learned to help the competition. Consider a non-solicitation covenant. Assignment inventions of agreement. Work for hire letters for independent contractors. Include covenant where employee promises to return trade secrets at the end of employment. So in other words, when a person's terminated or resigns, quits, you want to make sure that they don't take with them any information that would qualify as trade secrets. The one qualification there, and I think Ron's going to talk about this, is there's an Ohio Supreme Court decision about 10 years ago that held that what a person can memorize information that may be trade secret. So that you can have a person or an employee who leaves, and if they can go work for the competition or set up their own shop, and they may, by tapping into their memory, be actually misappropriating a trade secret. It hasn't been developed a lot, but it's a lot of exposure right there. All right, with that, I'm going to turn it over to Ron to talk about the Defend Trade Secrets Act.